We're not making up stuff on people. When you're a writer, how do you get your work out?
I don't care what people think. I don't care what they say. They can say what they want to say about me. I don't care. I got the talent to write and I'm gonna keep on writing.
We decided that we couldn't try this in the court of law. We're trying this in the court of public opinion.
Just pay me what you owe me. We putting this out here so you guys can see.
This has given us closure. I'm gonna put it to bed after this. I would get these responses from the staff that would answer the phone saying, he got that book on his desk. He got that book in his back pocket. He don't go nowhere without that book. He walks everywhere with that book. I would get this month to month, week after week while I was waiting. I was like, oh, okay.
I decided to bring 3 screenplays, to let them know I'm serious, about what I do, So I brought 3 screenplays with me, and me and her, we sat there and talked. She said she was gonna have to read it first, She was gonna have to read it first. I said, cool, you can read it. And she was gonna get back with me. So a week passed, I called her. She didn't call me, I called her. She said, yes, they love it. So they was gonna give me a call.
That you, Donna West, and all these other people were saying that they were writers that were wrong.
Right, because I know I did the same thing.
You was trying to find people?
I was trying to find people who been suing Tyler Perry and Oprah Winfrey. I was like, wow, I had discovered Tyler Perry was in so many lawsuits. I didn't know what to think at that point.
So we knew we weren't going to get justice immediately now. We were talking about document 1, how everything in that document is so different from our prior cases because this is civil RICO. Civil RICO requires there has to be prior predicate acts that you were connected to in order even to bring a RICO case.
Mm-hmm.
And so under civil RICO, the laws say that it does not require you or the defendant to have one in a prior litigation, or even that they had been convicted or even accused against and there had been a judgment against them in order to bring a civil RICO case. It's about the predicate acts. So this whole thing was a disappointment. How did you feel about the case overall? How do you feel?
I feel the overall case, I feel like we've been had. I felt like they cheated all the way through the case. I felt like we was betrayed by our own judicial system. It was like the judges were, it's like he was against us. The clerks was against us. A lot
of arguing and disrespect, right?
Yeah.
Do you remember that? How disrespected we felt? The way the clerks talked to us?
Yeah, and they tried to get me to go against you that one time, remember? What do you think the turning point was for you?
For me?
Mm-hmm.
I would have to say the pivotal turning point was when the judge allowed them to use that document 52, motion to quash for service of process, to get out of the defaults without giving excusable neglect. There wasn't a good reason. Whether you feel like this is copyright infringement or RICO, that's for a court of law to decide on a trial, because nowhere did we write anywhere that this is a copyright infringement case. The nature of the case is not copyright infringement, and all of the things we charge them with has nothing to do with copyright infringement.
But you know that's a pattern, what they did, right?
Mm-hmm.
That's a pattern. They do that. They go in default, and then they put a motion on the record like that.
Mm-hmm.
Turning point. So the judge can come in and snatch them right out of default.
Right. That seems to happen a lot.
Yeah.
I think also a pivotal point for us, I think, was when we did not understand why Judge Thrash entered on the record. Because at the time, we couldn't see the behind the scenes document where it says submission and judge terminated. We just saw Rich's story come on the record. They never disqualified him. They never gave anything saying he shouldn't be the attorney because he's not qualified to deal with this case.
Right.
He didn't approve their motion for reassignment.
Right.
And on a set of orders that just seemed out of nowhere, he reassigns it to Judge Thrash.
Right.
So after he reassigned it to Judge Thrash and Judge Thrash picked up the case, they said we saw where it says the documents, what we could see on the Pacer account, the documents was sent to Judge Thrash. So I was like, okay, and that was the discussion we talked about a few minutes ago. Mm-hmm. And I remember when I told you he may be fair and it'll be okay.
Mm-hmm.
What bothered me was when document 52 hit, instead of waiting for the judge to say whether or not he is going to let them out of default, they amended the complaint because we did a motion to strike. Now, you know what a motion to strike their answers should be responded by amending their answer.
Right.
But based on what they said on document 52, they're claiming they weren't served properly. So it's known that if you weren't served properly and you make that argument, and then you go ahead, put a Rule 12 answer in under Rule 8, right?
Right.
8B, your defenses and your counterclaims or whatever, your affirmative defenses, then you wait. It says once you're in default, you can't put nothing else on the record. You're not allowed to talk on the record. So I was like, okay, they can't say nothing. But then they came up and then they not only did they amend their answers, but they didn't do a Rule 12b-6.
Right. But you know why they did it like that, right? Not to cut you off, but don't forget your thought. Mm-hmm. But I just want to interject. The reason why they did it like that is because they wanted to start the case over again because they was getting the judge that they wanted.
But here's the problem. If you really believe this case wasn't supposed to move forward, and you really believe there was collateral estoppel and res judicata, collateral estoppel means it was already tried by a judge in another district, and res judicata is all the same parties. You and I have never been a party to the case. Oprah Winfrey has never been a party to the case. Tyler Perry Company, Studios, and Tyler Perry, the individual, has never been a party to the case with all of them included and all of us included, and neither has Lionsgate or Barbara Hunt. So it's all new persons of privities.
Right.
So that doesn't fall under res judicata.
No, it doesn't.
So this is what really messed my head up. Okay, even if you wanted to start the case over, because you think, oh, this needs to be dismissed.
It's a new
then
job.
You would have did See, this is how I could prove they know it wasn't res judicata, it wasn't collateral estoppel, and it wasn't what they said it was, no plausible claim based on the other case, because they would have filed a Rule 12b-6. A Rule 12b-6, instead of another answer on the record, would have said, there's no plausible claim that you can get relief from because this is collaterally estopped, ruled on by another judge, and this is res judicata. So I'm not answering that complaint. I'm filing my Rule 12b-6, and that's how it goes. You're not supposed to have an answer to the different charges of RICO and then say there's no relief, there's no answer. But you answered it.
Exactly.
So when you already use your motion to quash for service, that could have dismissed the whole case if the judge believed that they weren't served properly. But the problem was, not only did they know they were served properly, they knew that we had proof of service on the record, but they knew that all we would do is refile the case and serve them again and be right back where we were.
Yeah. And the judge, when Judge Story was on the case, Judge Story, he did everything by the book. When he got off the case and Judge Strass took over the case, then that's when they started putting in those motions to have it dismissed, because he was the one that they asked for. What was in document 30?
Document 31, yep.
Huh?
Document 31.
Document 31. So they asked for him by name. So once he got up there, they was like, well, we're gonna put in a motion to dismiss. We're gonna use res judicata and collateral estoppel to get out of this. And that's what they did. So
because he ruled on a prior case.
Right, all those motions that came up to Judge Strass was all those motions that you just mentioned. You know, so they was hoping Judge Strass just take it and just dismiss it.
But what's crazy about it, they put another answer on the record instead of a Rule 12b-6, saying no plausible claim.
They couldn't use a 12b-6. They knew that.
They knew it was a plausible claim.
Right, well, it wasn't the fact that they knew it was a plausible claim. They didn't use it because they didn't use it before. And that would have been easily found if somebody happened to look at the case. You know what I mean? How you gonna use a 12b-6 and you answer the case already? Right. So even if you amended the complaint, you still answered.
Right.
So that's why they amended it, so the judge, so they can do something slick. That was the purpose of the judge being on the case. Mm-hmm. You know.
Then when he took over the case and he came on, and immediately document 76, he ruled on document 52, but they had put document 74 on the record. And I'm like, mind blown. How are you still putting motions up and you didn't even get removed out of
default?
What are you doing? So now you think because you amended your complaint? So this is what they did. No. This is what they did. When we did the motion to strike their answers, right? That gave them the right to file the amended complaint, which is true. So now the case is going again. Then they did their judgment on the pleadings, right?
Right.
In their judgment on the pleadings was saying, based on our answer to the complaint, our amended answer, right?
Right.
We feel this case needs to be dismissed because they didn't properly argue civil RICO.
Right.
A judgment on the pleadings is not to answer that. An answer to the complaint is what answers that we didn't properly bring. That's what a 12b-6 is for. Right. See, that's what I'm trying to tell you. 12b-6 is to say you didn't properly bring the case, not no 12c. A 12c is based on the pleadings of what we wrote in the complaint.
Right.
So they did not argue one thing that we said in the complaint that they felt like that their pleadings was based on.
Right.
It was based on the documents that they presented outside of the complaint.
Right.
But if this was the same complaint that we use in our prior arguments and our prior cases, then you could have easily made a judgment on the pleadings to dismiss the case.
Right.
So now it's treated according to 12D, pleading matters outside of the complaint. It's supposed to be a Rule 56. That's a summary judgment. The judge allowed them to submit documents with their answer to the complaint. Those 11 documents was based on other cases in a RICO case. What defendant being tried for RICO goes and finds their other cases to bring to the judge?
Boom. Not only that, those other cases are predicate acts.
That's what I'm saying. Who goes and gets their own predicate act? Like, look, I got all these predicate acts that I want you to see. You don't do that in RICO. You don't bring in your predicate act talking about dismiss it based on this. It's RICO.
Right.
This is why the appeals court, when they did the jurisdictional question, was like, excuse me, can we just bring that up real quick? Can we just look at that document real quick?
Sure.
Yes. Let's look at the jurisdictional question. Okay. Because, and the reason why I think it's so important where did it go? Do it again. This is so important because, nope, I'm in the wrong place. Can you see this? No?
No.
If 54B certification was necessary to obtain the appellate review in this case, given the appellate review, both the district court and the orders, right? Their orders, 138, dismissing the plaintiff's claims on res judicata grounds and the defendant's pending counterclaim for injunctive relief would center around an analysis of the litigation, history between the parties. Please address whether the district court properly certified that there was no just reason for delay. So they said, did the district court properly certify there was no just reason for delay? And was there a history between the parties? So to me, that's kind of serious because you're asking the question if when you made those orders on document 74, their judgment on the pleadings, and they said it was res judicata, did you look at the history of the cases between the parties?
Right. Okay. Look, explain what res judicata again so everybody will know.
Okay, let's do this. Let's go back to this. Let's go here. Res judicata translates to a matter judged. Overview. Generally, res judicata is the principle that a cause of action may not be relitigated once it has been judged on the merits. Finality is the term which refers to when a court renders a final judgment on the merits. Res judicata is also frequently referred to as claim preclusion, and the two are used interchangeably throughout this article. Claim preclusion can best be understood by breaking it down into two subcategories. Bar, a losing plaintiff cannot resue a winning defendant on the same cause of action. So this proves the point that they should have never filed an amended complaint. They should have filed a 12B6. They shouldn't have filed a judgment on the pleadings, because there are no pleadings to argue if it's exactly the same as the prior cases.
Right, but that's where their judge came in. See, that's why the judge came in. He came right in and really didn't read the case.
No.
So now, funny, we were just mentioning that because the turning point for me was document 138.
Okay, well, let's do this. Let's go on to 138 and I'm gonna let you talk about it, okay? Let's go back to this. Here's 138.
Right. His orders.
Right. It says this is a pro se civil RICO action. It is before the court. The defendant's motion for judgment on the pleadings. Document 74 of the Winfrey and Perry defendants. All of the plaintiff's claims of copyright infringement are barred by res judicata and collateral estoppel. This is the third time the plaintiff has asserted these claims against the Perry defendants in Lionsgate Entertainment. She lost her cases in the Southern District of New York and in this court. Okay, well, let's see. Can you still see my my screen?
Yeah.
All right, so I lost a judgment right here.
Right.
This action having come before the Honorable Thomas W. Thrash, United States Judge, for consideration of the defendant's motion for judgment on the pleadings, and having granted said motion, it is ordered and adjudged that the plaintiff take nothing, that the defendant recover its cost in the action, and that the action be the same, and hereby is dismissed. Now, does it say what he dismissed this case on?
No.
Right. Do you think he was trying to be facetious when he did that?
It could be.
Since when do you not put what the merits are in your judgment against somebody?
Well, yeah, but you got to look at what was their judgment on the pleading.
Their judgment on the pleadings was based on
Copyright infringement.
Copyright infringement.
Right. Now, but that being said, now when you go back to the document 138, right?
See, this is about the document. This is about, we're looking at, do you want to go back to document 138?
No. You can.
Okay, there it is.
Okay, listen. Now, he said this is the third time that the plaintiff Tucker has asserted these claims against Perry defending Lionsgate and Entertainment.
Here, oops, right?
Yeah, but see, this is what he said. This is a pro civil RICO action.
There we go.
But it wasn't. Then he lied. See, this is a straight document. This just goes to show you he lied on this document. Because if he's saying this is a pro se civil RICO action, then he dismissed it on res judicata and collateral estoppel. Then where's it at? Where's the RICO claim? I mean, the RICO dismissal at? There's no RICO dismissal nowhere prior to this.
No, nowhere. And then when you look over here,
so this is a lie.
When you look at this case, remember what you said? This is his opinion and order. And he's talking about the book. The book. And he's talking about it being based on the movie Good Deeds.
Right. The first copyright. That is right there. Don't you see? Look, go up. You see where it says that it? Good Deeds and Friends, the copyrights of plaintiff's book. infringed the copyright of the plaintiff's book. Where it said, anywhere on here, what do it say is a RICO? That's
in fact, look, this is what they brought.
12B6.
And if this was the same as our case was the same,
it would be a 12B6 as well.
That's what I keep saying over and over again. His conclusion was that he says that I was collaterally estopped since the case was already litigated for substantially deciding.
Right.
So what does that have to do with this? Civil RICO.
Right.
He says here,
this is a
civil RICO action. And then
he tried to kill two birds with one stone. He tried to say this is a civil RICO action, but you pleaded last time a civil RICO action. This is the third time you're doing this. But then he messed up too, because if you go, where's this? See, if you look, he messed up. Check this out. It says this. Go back.
This one?
No, to the beginning. Right there. Check this out. It says, this is a pro se civil RICO action, right? For the court on the defendant's motion for judgment on the plea, document 74 of the Winfrey and Perry defendants, all of the plaintiff claims are copyright infringement. You see that?
Yeah.
Are barred by res judicata and collateral estoppel.
So here's the problem here. Let's do this.
He called it a civil RICO act.
And here's exactly what we're talking about now, so they could understand.
So this is a lie.
What does this cause of action say? This is our case. We're talking about the elements of civil RICO.
Right, cause of action.
At the top of our case, we said, this is civil RICO.
Right.
Then we come down here and we say, according to 18 USC 1961 and 64. Then these are the predicate acts. So this is 2319 is criminal copyright infringement. What about 2320, 1512, 1513, 2315, 1503, 1510, 1511, 1581 through 1588, 1341 and 1344? What happened to all those charges? Even if you could remove one of the charges from the complaint, what about the rest of the charges of the complaint?
But in neither one of those charges copyright infringement.
No, they're not. This here says right here, but
that's what he ruled on, though.
But we just said here, it is what? Criminal copyright plagiarism. That's not infringement.
Right.
So.
But he called this case a civil RICO case. See that? But then, as you read it, he said it's barred from res judicata and collateral estoppel. But this is not copyright infringement. And
then he says here, this is the third time that Plaintiff Tucker asserted these claims against them.
Right.
And that I lost my claims in the Southern District of New York. So did I?
No.
Okay. So here's an example. Here, we don't have this numbered the way they have it. So I'm just going to take a crapshoot and see what they put up here. This is in my case in New York that says that the case was closed on this particular date. And then they submitted this in document 33, which is their answer to the complaint. And it says here that he was directing judgment on the pleadings for them, right?
Right.
And then it says here, go again. Here it is. They said Donald is the author of the work entitled Bad Apples Can Be Good Fruit, copyrighted in 2007. Donald brought this copyright infringement action against defendants for their release of the 2012 movie Good Deeds, which Donald claimed infringed her protectable elements of her works.
Right.
So, I mean, that's the background of the memorandum in order here.
Right.
In New York.
That's your other case. That's your other case.
Yeah, this is New York, in the United States District Court of New York.
So where's copyright?
This is the same, what he says is the same as this. This is the same document. He's saying it's the same as this.
Right. How? How?
Like, I'm not understanding where he's getting his information from. And then he goes into and says that your rehearing in Bonk. No, this is mine. My rehearing in Bonk was denied. But boy, did he just show a lot of my documents. What about your documents? Okay. It says you haven't amended your complaint.
Right.
And they're dismissing it under a 41B with prejudice. So it says your complaint was supposed to be amended. So show me how this is RICO. I want to see RICO on here. I'm looking for RICO. Okay. Perry and James. Okay, let's see. Oh, wait a second. So, what happened? It closed out. Do you see that?
Yeah, I still see it.
It says my screen is paused. Okay. You see it?
Yeah.
It says here, William James's case is copyright. That's your owner. That's your script, screenplay, Lovers Kill. Right? It says that you registered with the Copyright Office. And it says you entrusted your work to Barbara Hunt, right? An associate of Oprah Winfrey.
Right.
And then Ms. Hunt presented the work to Tyler Perry for review and consideration, right?
Right. And
it says that it is a federal copyright infringement claim under 17 U.S.C. 101 and 17 U.S.C. 106. Okay?
Mm-hmm.
When you go back over here, what are our
right? What at?
Where that at?
Right.
How is this the same? So the judge said here in 138 that this is the second time that plaintiff James has asserted his copyright claims against Perry defendants in Lionsgate Entertainment. And you lost your case in the Northern District. But here's the biggest thing. A final judgment on the merits of an action precludes parties from bringing issues that could have been raised then. Didn't it say that under civil RICO, you can't bring the issues until you know about it?
Right.
So here it's talking about RICO, in which you can claim for damages. And the only reason why you can be dismissed is because you either fail to state that it is a enterprise. We did that, right?
Yep.
you can't say whether or not predicate acts. It says, considering broadening the scope of predicate acts, it seems most likely private litigants will have such a claim. You see that? Mm-hmm. It says, until Congress chooses to make equitable relief to private RICO litigants and expressly provide so, such relief should not be granted absent another federal claim. So we had to make another federal claim in order to make a RICO claim. Do you see? In order for us to have made this claim, we had to have other federal claims.
Right.
To create a predicate act. It says we have to show that there were 2 or more predicate acts in a RICO cause of action.
We showed like what, 10, 15?
We showed a whole lot. We have to show that the predicate acts constitute a pattern of racketeering. We also have to show that the activity defendant is directly or indirectly maintaining interest in the participated enterprise.
Right.
And it says predicate acts are those defined as racketeering under 18 U.S.C. 1961. So when you do that, which we did, right?
Right.
We went over here to the predicate acts. Here they are. This is what we charged them with. Look. We charged them with 506A, not 501.
Right.
This is criminal. This is for RICO. This is how you got to understand, RICO does not, you can't create a RICO argument until you have a predicate act of RICO.
Right.
And so in order for us to have brought this, you have to have, this is something that we went through, right? Mm-hmm. It says violations of RICO are punishable and you can forfeit any of your property. Imprisonment of not more than 20 years or life for predicate act offenses. So we can understand why they were fighting so hard. But this is civil RICO. So when you get down here to civil RICO, that's for criminal, right?
Right.
It says RICO violations are also subject the offender to civil liabilities. The courts may award anyone injured in their business or property by RICO violations treble damages, costs and attorney fees, and may enjoin RICO violations, order divestiture, dissolutions of their organizations, or restrict an offender future professional or investment activities. Civil RICO has been often criticized, and at what time commentators urged Congress to amend its provisions. Congress found little consensus on the questions raised by proposed revisions. However, the issue seems to have been put aside for at least the time being. So they're not going to stop us from using prior cases, whether or not you were convicted of RICO, Mm-hmm. And we had to have brought those predicate acts in order for RICO to stand. I mean, you can't just create a reason to give a person a RICO act if it doesn't have a prior action. And it says, while such a requirement has also been rejected by most courts, the Second Circuit recently chose to adopt such a limitation in all private civil RICO actions, which is there has to be at least 2 predicate acts convicted. Wait, oh no. That's not the same. That's convictions under the what do you call that? Under the criminal side. But then they explained under civil RICO, they just had to have the predicate acts. And we'll find that for them. And we have that. There was a ruling in the U.S. Supreme Court that we read yesterday that we showed you do not have to have a conviction. You just simply had to have the predicate acts. So they said here, the defendant appealed his conviction based on the trial court's failure to instruct the jury to prove the existence of a RICO enterprise. The government was required to prove the defendant's criminal gang and the ascertainable structure distinct the charges of the predicate acts.
We showed them the structure of it.
We showed them the structure of it. And we also showed them how they were directly involved. But these aren't the cases that we used in our case to prove our RICO complaint. We showed that, I believe, in document 61. Of course, I wish I had the stuff here a little bit better organized to understand so that we can easily. So the merits of the case, the phrase on merits refers to the case whose decision rests upon the law as it applied to the particular evidence and facts presented in the case. So there was no evidence of civil RICO. There was no evidence of prior cases presented in our other cases.
Right.
This is in opposition to cases whose decisions rest upon procedural grounds. The distinction between decisions that rest on the merits rather than on procedural grounds is important because a decision on the merits is considered final, right, and thus bound by res judicata. If a decision is bound by res judicata, then the parties involved in the case may not later raise those same claims in a subsequent case. Instead, a party that disagrees with the decision must appeal the decision, file a motion for a new trial, or file a motion to reconsider. Decisions that do not rest on the merits, however, are not bound by res judicata because the claims are not properly heard. Thus, these claims may be brought forth in a subsequent case, excluding dismissals due to a failure to state a claim.
Right.
So here's a problem. It says here they have to exclude from a merit failure to state a claim. It says that right here. They have to exclude anything that was on failure to state a claim. You failed to state a claim in document 41. I failed to state a claim. And didn't they say that's what the judge ruled on? Failure to state a claim?
Right.
Right?
Yeah, res judicata.
Yeah.
About don't stop you.
It was a 12B6 in my prior case.
Right. Mine too.
Yours too. It was a 12B6. But the problem is mine was really a 12C. So it's still failure to state a claim. These guys are creating their own narratives in the courts. And they're creating, so it says, under res judicata, the effects of a judgment extends to the litigation of all issues relevant to the same claim between the parties. We have no relevancy of the same claim between the parties. How is that relevant?
Right. Because this is criminal copyright infringement, not copyright infringement.
Yeah. So I'm trying to understand. Can you still see me?
Yeah, I can see you in the corner.
Okay. So here's the problem. They asked them, did you do a history between the parties? Here, the appeals court said in this section, did you analyze the litigation and history between the parties to say that you properly certified with no just reason for delay? Now, remember this Curtis Wright case? Okay. Let's see if we can find Curtis Wright. I thought we had him in here somewhere.
We did.
I thought we did too, right? Where's Curtis Wright? No matches. I thought we had that case.
We did.
We had a case?
We had it.
So it's just missing now?
Yeah.
Here it is. I knew we pulled it down. So, under this, right, it says that there was a 54B, right?
Right.
Which provides that when there's a claim for more than one action or counterclaim in the district court under a final judgment, right? That they say no just reason for delay. It says the Court of Appeals held that the district court had abused its discretion by granting a 54B certification, since the possibility of a set-off requirement that the status quo, be maintained unless petitioner could show harsh or unusual circumstances were made. So if you dismiss a case for want of an appealable order under 54B, you have to prove that you didn't abuse your discretion. They holding my mouse, Bill. I can't move it. They got my mouse. I can't. I'm gonna have to hit escape. To get my mouse back, I have to hit the escape button. Okay. The district court did not abuse its discretion in granting the petitioner's motion for certification under Rule 54B, right? In this, the district court held that. But it says in deciding whether there's a just reason to delay an appeal of individual final judgment in settings such as this, the district court must make an account of the interests of the sound judicial administration. It says the proper standard to which a district court exercise discretion in a 54B certification is to be judged is the interest of sound judicial administration under the standard, although res judicata of appeals must scrutinize the district court's evaluation of such factors in the interrelationship of the claims to prevent a piecemeal appeal. One such judicial concerns that have met the district court's discretionary judgment, then they wouldn't disturb it. Okay? So we showed that the judge did abuse his discretion, right?
Right, because he made a piecemeal appeal.
He created a piecemeal appeal. And it says, the Court of Appeals concluded that the district court abused its discretion by granting a 54B certification in its situation and dismissed the case for want of an appealable order. It also directed the district court to vacate 54B determination of finality because under Curtis Wright petition for rehearing and suggestion for a rehearing en banc, it was denied. Before judges dissented from that denial, observing the case was in conflict with the United Bank of Pueblo versus Hartfield. So this is what the appeals court presented to the judge.
Right.
The appeals court saying here that it had to be overturned because you said, the district court said that the 54B determined finality, right?
Right.
So when the judge ruled, it says here, nearly a quarter of a century ago in the Sears and Roebuck case, that's the U.S. Supreme Court, the court outlined the steps to be followed in making determinations under 54B. A district court must determine that it's dealing, right?
Right.
It says that it's dealing that it was a final judgment. It must be a judgment in the case, in the sense that it is a decision upon a cognizable claim for relief, and it must be final in the sense that, now we're going to show you something here. They want to hold my mouse. Okay, this is important. The U.S. Supreme Court says here that it must be a judgment in the sense that it is a decision upon a cognizable claim for relief, right?
Right.
Let's go to document 74. This is so important. Let's get back up here. Let's go to document 74. I thought I had it up, but it's okay. We can get to it again. Let's get to document 74. He granted 138 based on their document 74, right?
Right.
So, relief. The defendant said here, don't try to change what I'm doing. It says defendants seek no relief on this motion to the defendant's counterclaims, which are reserved. So, document 74, their rule 12C, right?
Right.
A judgment on the pleadings has no relief requested. But according to Curtis, right? It says here, and we're going to erase this and erase this so everybody can follow along, right? It says here that under Sears and Roebuck, U.S. Supreme Court. So U.S. Supreme Court orders on the steps of making a 54B determination, the district court must determine that it was a final judgment. And what? It says there must be a cognizable claim for relief. But we just looked at this. 74 says, what they say? They seek no relief. So on document 138, when the judge got in here, what did he say? He said the clerk is directed to enter
Into a final judgment in favor of the defendants and against the plaintiff on all plaintiff claims pursuant federal civil procedures 54B, being that there is no just reason for delay.
So how could he have given them the case, and why were we sitting in the appeals court? Now, here's the worst part of it, right? We're going to get to this right here. This is very important. We're going to go back out of here, and we're going to show something very important.
Hold on. Here goes something important right here.
Okay, you still on the screen?
It's on the same note. It says, and all of these requirements have been met here. In addition, the plaintiffs failed to state a plausible claim of copyright infringement as a predicate act.
Right here.
For a RICO claim. You see that?
So, a plausible claim, failure to state a plausible claim. So let's remove that again. Let's remove this, right?
Mm-hmm.
This is what you need to concentrate on right here. It says plaintiffs failed to state a plausible claim of copyright infringement for a predicate act of RICO. So now he's admitting it was never a claim for copyright infringement. He's admitting that it was a plausible claim for copyright infringement,
right,
as a predicate act for civil RICO claims. That's not quite the same thing.
No, he's admitting that there was no copyright infringement claim on this case.
But there was.
But it was criminal copyright infringement.
It was a predicate act.
Right.
He's admitting right here that we claimed it as a predicate act, and he's saying that we didn't do it properly. And when you see this, failure to state a claim, this is why I did this. I'm going to show you something important. And this is what we want people to see on our case. Okay? We want them to see this. And it says here, under Rule 12, right?
Right.
Under Rule 12 for defenses and objections to a complaint, right? It says, I don't know why I went so far. It's still not, they're holding my stuff. Okay, so here, this is, give me my mouse. Right here, this is a 12B. How to present a defense. This is a 12B6 failure to state a claim, right?
Right.
You looking at that?
Yep.
So let's look at this. What does this say?
It's a 12C.
So did they ask for relief in here?
No.
And is this a 12B6?
No.
So how can they state we failed to make a claim? Right here. A judgment on the pleadings is not for a failure to make a claim. It's not the same thing. Look, they make it more clear here. Okay? Saying our claims are barred. How are our claims barred?
When it's not copyright infringement. He just stated it up there.
Then they're saying that our civil RICO claim is legally insufficient.
It should be dismissed.
So is it copyright infringement or is it RICO?
Right.
It says, here it is. What should this be? A 12B6, right?
Right.
So here's their argument that we failed to allege any predicate acts. Then here on 138, they said we failed to, what did we fail to do?
Make a plausible
claim for predicate acts on the orders.
Right.
These are the orders. They said that we failed to state a claim, right?
Right.
That we didn't make an adequate claim.
Right.
And according to Rule 12B6, this is a presentation of a 12B6 claim. And this is supposed to be, it's supposed to be asserted defense by a motion. It's required to be asserted by a motion.
Mm-hmm.
This is a defense for a claim for relief on a pleading. So a 12C, judgment on the pleadings, after all pleadings are closed. This is them messing with my mouse. And this is what I'll tell y'all they do. So here is what they filed. Were all pleadings closed when they made this? When they did this, were all pleadings closed? No.
Yeah, it was.
When they did document 74, all pleadings weren't closed yet.
No, it wasn't closed with document 74.
And it says, if you do a judgment on the pleadings, right?
Right.
It becomes a 12D when you present matters outside of the pleadings. So because document 1, wherever this may be, where is document 1? Cannot find it. Oh, it's way back here somewhere. Vertical sides. Okay. Document 1 says our predicate acts, and it says what they are. We said it was for criminal copyright plagiarism, right? We said it's for trafficking counterfeit goods, tampering with retaliating. Here they go, messing with my, you see? This is what we had to deal with the whole time we was fighting them. Grabbing my mouse and doing stuff, tampering with retaliation against qualified attorneys. Obstructing justice. This is what we said that this case is based on. Counterfeits, plagiarisms, threats, violence, and forgeries. What are they doing? You see this?
Yeah.
This is what we deal with, and this is what they've done. So, how this judge could have ever ruled, their document 74 is saying here that we failed to plead civil RICO, that our claims are time barred. But according to RICO, it's at the time that you discover RICO.
Yeah, but they saying our plaintiff civil RICO claims are time barred because of res judicata and collateral estoppel, because we already did that already. Basically, is what they're saying.
No, they're saying because we brought it after 4 years.
Right.
But RICO doesn't accrue until after.
You find out about it.
Right. Okay. They have made a big story, but nowhere have they asked for relief. They said that plaintiffs would not be entitled to relief under any state of provable facts. How is this right for them to say this here?
Right.
How can they say that? How can they say that when document 1 shows the predicate acts right here? These are the provable facts.
Right.
I mean, it doesn't take a rocket science to
Genius.
to say that the predicate acts are the cases, right?
Right.
So here, this is copyright infringement. Copyright infringement, those are predicate acts.
Mm-hmm.
Copyright infringement, predicate act. 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 So how many?
Tyler Perry.
This is only for Tyler Perry. That's the party. So, and that was just a search done.
Yeah, right there.
Yeah. Tyler Perry for all courts. So the time period, it has to be within 10 years. This 2007, ours was filed in 2017. That's exactly 10 years. This 2015, that's within 2 years of our case. See? 2015, that's within 2 years. So we already got right here, we got 2, right? This was done in 2006, that's 1 year late, but it's okay because 2013, that's a predicate act. That's your case. This one's my case. That's 2 predicate acts. That's all we need, right? But then there's one in 2012, 2011, and there's one in 2010. Then there's one in 2009 again, and there's 2007 up there. So the predicate acts did take place within 2 years and 2 predicate acts.
Within 10 years.
Okay. This Oprah Winfrey, this the party. It's all Oprah Winfrey, right?
Mm-hmm.
So let's see. She got a RICO case. That's a predicate act, right?
Yeah.
Okay. This is civil. This is a copyright infringement. That's a predicate act. That's copyright infringement. Predicate act. This is in 2000. This is in 2008. This is in 2010. Let's keep going. She got another page. Here's copyright infringement in 2011. This is still party. Oprah Winfrey. Keep going. This is another RICO case in 2014. Copyright infringement case, 2006 or 8. That's 8. Another copyright infringement case, 2007. Another copyright infringement case in 2009. Another copyright infringement case right below it in 99. This ain't new to them. Okay? This is party, Oprah, right?
Mm-hmm.
And over here,
all them copyright infringement.
All copyright infringement. 08, 97, 99, 2010, 11, 6, 7, 16, 9, and 99. And this 2016 was not us. We didn't file ours yet. Ours wasn't filed to April the 3rd of 2017. That's 3/25, 2017. All Oprah Winfrey under 820, which is copyright infringement. And just so that you can understand, we're going to show you, just to remind you, when you file a lawsuit, you have to do this civil cover sheet, right? This is what the civil cover sheet looked like. Okay? This one is William James and I right here against the defendants. Here they go, right? Mm-hmm. So now you scroll down here to this section. The second page is called the nature of the suit. And here, this is where it would have been copyright infringement. You put an X there. We didn't file that. We filed over here, 470 under racketeering. So we just want you to see right here, 820 is copyrights. 820 is copyrights. We did not file a copyright claim.
But this is what the judge said we failed to do.
He said we failed to file for predicate acts under copyright infringement. So this is document 1. This is our predicate acts that we submitted. See, this is, let me show you. Well, if I can get my mouse back whenever I get it. This is document 1 in our case. Okay. And this is the case that we filed. Okay. On 4/3/2017 is when we filed our copyright infringement. Our civil RICO case together in Atlanta, Georgia. This is the case number. This is the date it was stamped in. And here you see William James, and you see my name, and you see their names. If I can just stop it from rolling so fast. We said this is a verified complaint for damages of RICO. See this? This is for damages for racketeering, conspiracy to engage in a pattern of racketeering activity and related claims. This we claimed as civil RICO. We also claimed it as Sherman Antitrust Act, Clayton Act, and violation of the U.S. Constitution against them. So we don't know how this got. I don't know what somebody is doing on my computer, but I'm trying to fight to keep it where we need it. So here, this is our argument. We explain that this is a complex civil RICO action under RICO, okay? Mm-hmm. We said that we are authorized under 18 USC to file this RICO. And we said the primary cause of action is that the defendants in a widespread criminal enterprise operating under a cartel for legal businesses engaging in the pattern of racketeering activity and across state lines. And we said the RICO predicate acts over the past 10 years. And then we told them to see the Exhibit A. And then we said the predicate acts cluster around, what did we say?
Criminal copyright infringement. Criminal
copyright plagiarism.